Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. Later on in the program, a one-on-one with State Treasurer Walker Stapleton over PARA. That's right, the state-run retirement association, and it's in trouble. But first, a little Obamacare with one of the guys who stuck his neck out early on a lawsuit against Obamacare, our very own Jon Suthers, State AG. Thanks for coming back. I appreciate it.
Glad to be here, John.
What was it that led you to be one of the first attorneys general, on a state level to say, we have to stand up to Obamacare? And that really started a rallying point. And now how many AGs are working with you on the suit?
Well, 28 states. Some of them are governors. The vast majority of them are AGs. In the 6 months leading up to President Obama signing the bill and it working through Congress, there was discussion about how Congress would try and implement a health insurance mandate. As early as 1994, the Congressional Budget Office had warned Congress that if the Congress directly mandated each individual in America to have health insurance, it would be an unprecedented expansion of federal power. Never had the federal government reached out and said to individual Americans, you have to buy that product. So we were convinced as AGs that we weren't going to have that kind of an affront to federalism. They were going to try and coerce the states to do it.
In other words, you were thinking there's no way Congress would actually say, you will buy something or else we will punish you.
Yeah, what we thought was going to happen is they were going to say, if you want Medicaid, you state have to force your citizens as a state to buy health insurance, which is kind of a method they regularly use.
And they use that in lots of things. For instance, our drinking age is 21 because they were going to hold up our transportation dollars. We changed our DUI levels, which I thought were pretty commonsensical and better than most states, to something standard to other states. Otherwise, you don't get your money back. So you were thinking, I think it was pretty reasonable. Hey, you want the match you spend on Medicaid? Well, you better do exactly what Washington tells you.
And then lo and behold, in the final analysis, they didn't do that. And we had had consulted with a lot of constitutional law professors. There are a few conservative constitutional law professors out there that had given us some research on the individual health insurance mandate if the federal government tried to impose it. And we were ready to go. And I think about 5 states originally brought the suit the same day that the president signed the bill. And as time has gone forward, other states have been added, and importantly, we also had the National Federation of Independent Business join us as a plaintiff early on.
This is on the federal level?
Yes, right. Because we anticipated that the federal government would claim that the attorney generals don't have standing to bring an action for their citizens, and so we wanted businesses in there also. As it turns out, standing has not been a problem for us.
Well, let me bring this down to a level I can understand. So the Congress passes this law, and it says, if you breathe, you must buy this policy. If you can't afford to buy this policy, we will somehow get you the money to do it, but you must buy this. Has there ever been anything in the history of the United States where the federal government, not a state government, but the federal government says, hey, you breathe, you're buying something?
Not under the commerce power. At one point in time, the federal government said, you have to raise a militia, you buy a gun and bring it to the Revolutionary Party. But that was under the power to raise armies, never under the commerce power have they said, you must buy this or we're going to fine you. And the fine, of course, is a percentage of your adjusted gross income if you don't have
Now, the commerce power under, let me see if I've got all this right, under Section 1, Section 8 of Article 1, it enumerates these are the limited things that Congress can do. They can declare war, they can coin money, they can run post office. What a bad decision that was. They can take care of trade. They can take care of the Navy. They can
copyrights,
patents, and they can regulate commerce between states, which, if I remember, tell me if I'm right, because you were closer to that period in age, so you probably remember when they did this. They did it because they didn't want states erecting trade barriers so that Pennsylvania would say, oh, sorry, you want to bring your crops over from New York? No, we're going to put a tariff on them. Wasn't that that was the founders' thought?
That's exactly right. Prevent states from erecting trade barriers to interstate commerce. That's such a small part of the commerce power today that they now call that the dormant commerce power. And what's happened in the last 200 years is essentially the commerce power has become the ability of the federal government to regulate any economic activity that impacts interstate commerce. But that's the key to this. There's no economic activity. You're sitting at home, sitting on your couch, and the federal government's saying, how dare you don't go out and buy what we want you to buy.
Now, this Commerce Clause has even worked in medical marijuana, illegal economies, and Scalia has agreed with that, saying, well, you know, if there's a law here or somebody's making medical marijuana here or even illegal marijuana, it has effect on the black market, and therefore Congress has the ability to pass laws. But even then, it's about people choosing to enter into transactions.
That's right. In a case several years ago, marijuana grown in California, sold in California, the court said 5-4. It impacts interstate commerce. Therefore, the federal government can regulate it. But as you point out, growing and selling marijuana is economic activity.
Let's get into the nitty-gritty here, because the election is coming up in a year, and Obamacare was the signature bit of legislation that will define this presidency, and it changes everything. If this act becomes constitutional, if it's declared, yes, Congress has the power to force you to buy something you might not want to buy, what can't Congress force you to do? Would there be any limit?
I don't think so, and I think that's the problem. As this case has gone through the courts, the federal government's been asked, what's the limiting principle? And they keep saying health insurance or health care is the limiting principle. So we couldn't do this. There's something unique about health care and health insurance. But when they're closely examined, it doesn't hold up as a limiting principle. And we're convinced that the federal government, if it decided to promote interstate commerce, you need to buy a car. And by the way, you have to buy a fuel-efficient car. They could use the interstate commerce power to do that.
Or couldn't they also say that I need to have a retirement account, that I have to have a 401k and I have to put this much into it?
They might. I think it's more likely they'd make you buy solar panels to deal with global warming and things like that.
Where does the case stand? I've heard that there's several different venues. So you and 28 other states working with the NFIB went through, the first case was in Florida, I believe, and then there were other ones in Virginia. There are several different cases popping up in different areas.
There's 3 cases now that have gotten through a circuit court of appeals. In one case, in the 6th Circuit, they held for the federal government. In a case out of Virginia, they basically said the AGs don't have any standing, and that was a case the state of Virginia won in the trial court. In our case, we won in the trial court, Northern Virginia. We won in the 11th Circuit. So we now have what are called split circuits. Under those circumstances, the Supreme Court really has to take the case. Otherwise, some of the country would be under one law and other parts of the country.
Let me kick it back, see if I got this. So you've had different cases. One circuit says, oh, no, it's constitutional. Another one says, no, it's unconstitutional. Does that guarantee that the U.S. Supreme Court has to weigh in on this?
It virtually does. It doesn't guarantee the time frame. It guarantees they will. But the way things are shaping up, it appears that the court's going to accept the case this term, set it for argument late in the term, and decide it perhaps next June before the 2012 election.
So it's possible that we will know whether Obamacare is constitutional or not before the next presidential race.
I think it's very possible. I think that's a good scenario for our side of the political fence because I think it's no winner for the president. Either his signature health care bill is unconstitutional, or the voters who disapprove of this mandate, like 56%, are going to say we're going to have to make a political change because we didn't win in the courts. We're going to have to make a political change, and I think it would have a real impact on the 2012 election.
I know you don't have a crystal ball, and you're very conservative as a lawyer and as our AG, but play with me for a second here. If the Supreme Court has said that illegal activity like marijuana can be regulated under the Commerce Clause by 5-4 vote, what makes you think that the Supreme Court has a shot of going our way on this, which it seems to be blatantly unconstitutional? How do you give the odds?
John, this is a real constitutional Rubicon to say we can now apply the Commerce Clause to situations that don't involve economic activity. You know, because you're not buying a product impacts interstate commerce, we can force you to buy that product. I mean, that's a big leap. And the key to it is whether, my guess is the 4 liberals on the court are willing to make that leap. There's 4 conservatives that are probably not. The unknown question is whether Anthony Kennedy is willing to make that leap. If he's not, we win. If he is, the other side probably wins. That's what it boils down to.
So we have to make sure there are no heart attacks on the Supreme Court between now and then. All right, Anthony Kennedy, you have a sense?
The only thing that I'll say, there's in the AG community, there's a couple of ex-clerks of his who say that he's very protective of federalism, and that's what this case is all about. You know, for a lot of people, it's been an emotional policy thing. I don't want the government telling me to buy health insurance, but from a strictly legal, constitutional standpoint, this is all about federalism.
Yeah, let me ask you about this. I imagine you're not a big fan of a government forcing you to buy insurance, whether it's a state government or the federal government. But for you, if the state of Colorado said you have to buy insurance, would you be fighting this?
No, absent a provision in the Colorado Constitution that said they couldn't do that, they could do that. And it'd be a whole different ballgame.
Why? Explain that to me. Make it simple for me to understand.
Under the principles of federalism, the government has only the limited powers given to it, Article 1, Section 8. The states and the people have all the rest of the power. The state can exercise any power not deprived it in the state constitution. So the state, as the Constitution reads right now, could force you to buy insurance or fine you if you don't. Whether that's good policy or not, they could do that.
So in other words, when the state of Massachusetts put in their policy and said you will buy health insurance, you wouldn't challenge that. I would challenge it as very bad policy, but you'd say there's nothing in the federal Constitution that bans that.
No, and it's certainly not an affront to federalism to let the state do it. But to have the federal government do it is a whole different ballgame from a constitutional standpoint.
This law is what? Thousands of pages long.
2,000 or 3,000.
I mean, and it creates all sorts of departments, and we're just starting to understand how restrictive and bureaucratic and open to interpretation this is.
And the administration's abandoned portions of it already.
Yeah, so that part's not workable, but it's law. I don't know how you abandon it. Let me ask you, if you win, does the whole thing get tossed out, or will it be severable so that only the mandate part gets tossed out and all the other bureaucracy stays?
Yeah, that's an interesting question. The trial court said, I'm taking the federal government for its word. They've told me it's part and parcel of the whole thing. Therefore, I'm throwing out the mandate and I'm declaring the whole thing unconstitutional. The circuit court said, no, we're throwing out the individual health insurance mandate. We're not throwing out the whole thing. I think the Supreme Court's likely, if they throw it out, to do that. The question whether is anything else can stand if this is gone.
If the funding mechanism stops.
That's right.
AG, thank you so much. It's going to be the suit of your lifetime, I bet.
I'm looking forward to it.
Stay tuned. Walker Stapleton joins me.